Good evening, Council and staff. May I have a mover and seconder to call the meeting to order, please? Councilors Garwood and Deputy Cabral at the special meeting of the Council of the Township of Springwater, May 7th, 2025, come to order at 5 p.m. All those in favor? And that has carried. Are there any disclosures of pecuniary interest? And not seeing any, and seeing that we do have John Mascaron online, I will now call upon John Mascaron to provide a presentation regarding the strong mayor powers.
Good afternoon, Mayor Coughlin and members of council. You can hear me okay?
We can, thank you.
Terrific. I have a slide deck presentation that I think might assist in the in delivering this this presentation today. Is that all right if I can share my screen, Madam Mayor?
Yes, thank you. Do you prefer that questions are asked as we go through the slide or held to the end?
Madam Mayor, I'm in your hands. I'm happy to have them throughout, but I won't be paying attention if anyone raises their hand. So I'm in your hands. If you would like questions to be throughout, I am perfectly okay with that as long as you stop me and say there's a question.
Perfect. Thank you.
Great. I think you've got the slide deck up now. Strong Mayor Powers, today's date?
That is correct.
Okay. Terrific. Thank you. So good afternoon, members of council. I'm going to present today on the strong mayor powers, which is essentially what is in part 6.1 of the Municipal Act. And I'll talk to you a little bit about that in just a moment. That's going to be my presentation. I will, at certain points, also make reference to things that I've learned now in looking at the strong mayor powers. I was advising some councils, some municipalities that were in the first tranche of delegated powers or designated municipalities back, 2 years ago. And I've certainly learned some things. So I'm going to try as best I can when I'm presenting on some of the substantive things, also some things that I've learned and maybe some of the information that I've gathered. Hopefully that might help you understand where some of this is coming from, and if potentially might even serve to answer some of the questions. So, as by way of quick introduction, you have a book that's written by our premier and his late brother Rob Ford, the former mayor of Toronto, back in 2016 by a reputable publisher, Ford Nation, Two Brothers, One Vision. And this quote was attributed to now Premier Ford, before he was premier. If I ever get to the provincial level of politics, municipal affairs is the first thing I would want to change. I think mayors across the province deserve stronger powers, one person in charge with veto power. So, in case you thought this was drummed up just a couple of years ago, it actually was a vision that our premier had and some idea that he had quite a while back. And of course, this is all informed by his time as a one-term city council member in the city of Toronto, having watched his baby brother, Rob Ford, maybe take his lumps a few times at city council when he didn't get what he wanted. Many times the vote was, I think at the time it was 42-2, 43-2 sometimes, with the two Ford brothers being in the minority. And I think Premier Ford saw this and thought, if the mayor had strong powers, perhaps the mayor wouldn't be underfoot of the members of council. So there is the vision. So now you got this vision. How do I implement? What do I do? What's my excuse? Well, you have the Ontario housing shortage. The Affordability Task Force developed to look at housing here in Ontario. The report came forward February of 2022, and it said, first line of the introduction, Ontario's in a housing crisis. Why? Why was it in housing crisis? And look at all the fingers being pointed to municipalities. Development restrictions, because municipalities set OP designations, zoning bylaws, right? Development charges, development fees, levies, building permit processing fees, planning processing fees, all things that a municipality imposes. Why? Because the municipality is basically in charge of land use planning approvals across the province. And then finally, what's the other culprit? Building permit delays, because building permits cannot be issued quickly enough by chief building officials because inspections aren't done quickly enough. Well, this is a very interesting thing, because if you consider all of these matters, remember, constitutionally, the province controls municipalities. Municipal institutions in the province are under the jurisdiction of the provincial government under Section 92 of the Constitution Act. So these are all things that the province has downloaded to municipalities, and yet the fingers are being pointed to municipalities being the culprit. So what does the province do? The province looks at the Housing Affordability Task Force report and says we need to build 1.5 million new homes in 10 years. So the recommendation that comes forward is there is a building target that the province set to have 1.5 million new homes built in Ontario by December 31st, 2031. Okay. Since then, the province has actually acknowledged that this is a baseline. It is the minimum that is required, and actually more significant action is needed, and more homes are required to be built. Okay. So you've got those two things, the vision and then the way of possibly finding, hey, maybe we should be implementing it to do something about this. Well, that goes against the traditional local democratic government system that's been in place throughout all of Canada and has been in place since pre-Confederation here in Ontario, when it was still Upper Canada back in the 1700s. We have what's called a weak mayor system. Now, that's not because mayors are weaklings. That's not how to read this. It just means that the system that's been put in place, the local governance system, basically says the head of council is the spokesperson, the representative person for the municipality. The person is a leader among equals. Typically, the council is one vote per person, including the mayor. So mayor only has one single vote of council, and traditionally has always had a very limited unilateral executive authority. You can probably think of two things that come to mind. One, the mayor's authority under Section 241 of the Municipal Act to expel anyone who's been disruptive at a council meeting. The mayor does not have to ask anybody to do that. The mayor has the authority to expel a person. The mayor also is the person who can call a state of emergency under Section 4 of the Emergency Management Civil Protection Act. And the mayor is the person who implements the emergency plan and can have certain powers. Now, those are just two unilateral executive authorities that the mayor has. I ask you, what other ones can you think of that aren't delegated powers? There's not that many. There really aren't. That's why the system is a weak mayor system. There was a paper, Strong Mayor, Weak Plan. And I really like this one quote. The role of the mayor has traditionally been viewed as a consensus builder, one where the head of council must work together in a spirit of cooperation and compromise with the other elected representatives of the municipality, i.e. the council members, to achieve a desired result. That has been the system in place in Ontario for over 200 years, and it is the way that all local governments are run throughout all of Canada. There's no other jurisdiction, actually, that has a strong mayor authority in Canada. Now, there are strong mayors in many other jurisdictions. The U.S. is the one that this current government often points to and says, look, there are strong mayors in San Francisco, New York, Los Angeles, and particularly Chicago. And if that strikes you as interesting, well, it should be, because the premier's father's business, or former father's business, deceased father's business was Deco Labels and Tags, whose head office is in the States, is in Chicago. So Premier Ford and the Ford family know Chicago very well and always proffer it as a way that government should be run, with a strong mayor at the helm. And this is admired in the Municipal Act. That's how it's set out. The powers of a municipality are to be exercised by council. That's under Section 5.1. How are the powers supposed to be exercised? Well, typically, although not exclusively, by bylaw, unless the municipality is specifically authorized to do otherwise. And as you probably have read in the Municipal Act, there are, at least 36 separate instances in the Municipal Act alone where council can give approval, council can pass a bylaw, a resolution, council can do certain other things. And of course, council can, in a closed meeting, also give directions to staff to implement the will of council. So those are things that are the municipality is specifically authorized to do otherwise. But typically, the only authority is, unless it's been set out in a statute or it's been delegated by council to the mayor or to anyone else, another officer, a committee, or a staff member, then it's council that has to make the decision in order to do something for the municipality. So let me now turn to strong mayor powers. There are 4 separate sources for strong mayor powers, and I will be going through them in some detail this afternoon. So there are 2 statutes and 2 regulations. Let me just say, you have to read these together. You can't just go to the statute and understand it completely. You can't just go to the regulation. The regulations typically are much more detailed and set out rules, procedures, and other things in order to fulfill, in order to put in place the authority of the powers that are set out in a statute. So you've got the Strong Mayors Building Homes Act. You'll see it's Bill 3. This act was brought forward. It was introduced in the legislature shortly after the current provincial Conservative government won its second majority in 2022. There had not been a mention anywhere during the campaign or before, except maybe if you want to talk about the book again, about strong mayor powers being granted. But yet, you have the new provincial Conservative government taking power as a majority, and then all of a sudden, Bill 3 coming forward. Bill 3 of that sitting of the legislature. So it's very, very early on. This caught many, many people off guard. What did the Strong Mayors Building Homes Act do? It added a new part to the Municipal Act and that other statute that I referred to by its acronym, COTA, the City of Toronto Act. What it did is it added Part 6.1, which is entitled Special Powers and Duties of the Head of Council. It added those to the Municipal Act as well as to the City of Toronto Act. Okay. Now, a little bit later on, the legislation was passed in September, introduced in August, I believe, and passed in September very quickly. The province, I think, forgot to do one thing, and it passed the, unfortunately, ironically entitled Better Municipal Governance Act 2022, where it added one new section to Part 6.1 of the Municipal Act. Now, it's only one section, but it's really a significant power, and I will spend some time to tell you what that is in just a moment. Now, together with this, you have to read the regulations. There is OREG 530-22, which is the authority that actually designates municipalities with strong mayor powers. as you will recall, on April the 9th, earlier this year, the province set out a press release. And the press release said the province is intending to extend strong mayor powers to another 169 municipalities. And it showed a list that you could link to. That list is what was proposed to be the list that would go into Section 1 of Regulation 53022. So Section 1 is the provision that says these municipalities have been designated to have strong mayor powers. The Minister of Municipal Affairs and Housing, under the statute, under the Municipal Act in Section 284.2, has been given the regulation making authority to designate municipalities. So when the reference is to the province, that's just a generic reference. Really, it's the Minister of Municipal Affairs and Housing, now Rob Flack, who has the statutory authority to designate municipalities. And as I indicated, on April 9th, notice was given that 169 new municipalities were proposed to be granted strong mayor powers on May the 1st, 2025. And as you've discovered, the Township of Springwater was on the list. And as you have discovered, because the minister sent a letter, I'll show it to you in just a moment, that on May the 1st, the minister went one better and actually designated 170 municipalities to have strong mayor powers. Okay, now what Regulation 53022 also does, and that I will speak to, is it also sets some technical and procedural rules for how the strong mayor powers are to be used, discharged, and implemented. And I'll speak to some of those as I'm going through. And now I want to be absolutely clear. Your clerks will have a lot of work to do to keep all of this running smoothly and without any issues. That's going to be a tough task because there are a lot of procedural regularities that they will have to go through. I won't be getting down into that granular detail today. Those are all things that your clerks are paying attention to and will be working out as you go along. AMCTO, the Association of Municipalities Clerks and Treasurers, has put out a toolkit for municipalities having to deal with this and have been instituting meetings on Friday afternoons for anyone who would like to join, particularly clerks and treasurers, to understand how the minutia of the details might be working for this statute. I will touch upon those, but I won't be getting into the fine granular details. And then finally, there is Regulation 58022, provincial priorities. This regulation in one section prescribes priorities that this government feels are provincial priorities for housing and infrastructure related to housing. I will show you the regulation, and I will tell you now that there are 3 specific powers in Part 6.1 of the Municipal Act that relate only and exclusively to the provincial priorities as prescribed by regulation. So those powers can only be used to carry out, implement, or not interfere with provincial priorities. And I will speak about those. Okay. Now, initially, I'm just going to talk just quickly now about how the rollout of the strong mayor powers was done. The powers were initially granted only to the mayors of Toronto and Ottawa. It was stated absolutely clearly by the Premier, as well as by the former Minister of Municipal Affairs and Housing, Steve Clark, that this was a pilot project. They used those specific words, and that the mayors of Toronto and Ottawa were being granted these powers expressly, specifically, because those were the two most municipalities that were most in need of housing, and particularly affordable housing. And again, in the words of Minister Clark, were shovel ready to get going. So the mayors at the time, Jim Watson in Ottawa and John Tory in Toronto, were given the powers. Interestingly enough, Mayor Watson says, I don't want anything to do with them. And it came out later that Mayor Tory had been lobbying beneath the surface to get these strong powers from the province, and he readily embraced the powers. About a year later, on June 16th, 2023, the province announced that 27 additional municipalities would be designated as strong mayor municipalities as of Canada Day 2 weeks later. There wasn't any condition put to that. And then a short time later, which I think caught some people a little bit surprised, there was a third tranche of municipalities that were offered the opportunity to become strong mayor municipalities. And I say that deliberately. They were offered the opportunity. There were, I believe, and I stand to be corrected, 22 municipalities. There may have been only 21, but I think there were 22 that were proposed to be designated under Section 1, provided that not the council, but the mayors of these municipalities would sign on and execute a pledge to commit to the provincial housing construction targets as the province had put in place at that time. The mayors were given, the heads of council were given an opportunity to do so. I think they had about 3 weeks. They had to do so by October the 15th, 2023, in order to have the powers on Halloween of 2023. You'll see by my slide, only 18 actually signed on. There were various issues. I think Haldimand County, Norfolk County, I think, and New Tecumseth were 3 municipalities, and I can't remember the fourth. That's why I'm not sure if there was 22 or 21. Actually did not sign the pledge, and so therefore they weren't granted the powers. Then you saw the press release on April the 9th, Ontario proposing to expand strong mayor powers to 169 additional municipalities. No prior notice had been given to municipalities of what the province referred to as proposed powers to be granted on May the 1st, 2025 to, interestingly enough, single tier and lower tier municipalities, not upper tier municipalities, which might give you an indication of where the province is thinking about for upper tier municipalities. And instead of looking at population growth, which had been one of the criteria for earlier granting strong mayor powers to municipalities. Initially, I think it was 100,000, then it became 50,000. The province this time said, well, we're not going to look at population, we're going to look at councils that have 6 or more members. So, if you're wondering how did they choose the township of Springwater, that was it. Because you have a council that's more than 6 councillors. Your council is more than 6 members. So, and there were a number of very sweet statements made about how wonderful the provincial priority delivery has been, how it will serve to cut all the bureaucracy, and so on. That, by the way, that cough was just was not for effect. I was actually coughing. And then on May the 1st, you have this letter, which was sent to all municipalities that were given strong mayor powers. This was written by the Minister of Municipal Affairs and Housing, Rob Flack, on May 1st. To follow up on our government's announcement from April 9th, he's very pleased to inform you that you have extended strong mayor powers because you were getting this letter. And that was given to 170 municipalities. By the way, as I showed you just before, the announcement on April 9th was very unusual because it wasn't like all of the other announcements that had come forward. There was an option, admittedly, for the third tranche where there had to be a commitment. Here, on April the 9th, the province indicated that this was going to be put on the registry, on the environmental registry for commenting, and it said it was on for 1 week till April the 16th. I think that led a lot of municipalities to believe that if perhaps the municipality did not want strong mayor powers, and when I say that, what I mean is the council, perhaps together with the mayor concurring, did not want to be designated as a strong mayor municipality, that it had an opportunity to register the comments or even write to Minister Flack and say, please don't put us on the list. Now, I know for a fact that a number of municipalities, a number of my clients did write to the minister, did put comments to that effect. And yet, strong mayor powers were granted to everyone whom had been given an indication that they were on the list. So it was very interesting here. You had proposed powers that yet came through whether municipalities wanted it or not. So one of the questions that you may be asking me, and I'll just cut to the chase on this, is can you disclaim the strong mayor powers? I think it's too late. You've been put on the list now. You're now listed in Section 1 of Regulation 53022. I don't think there's any turning back the clock at this point. I don't think a municipality can write to the minister, write to the province, lobby somebody, and have the powers revoked at this point, at this particular moment in time. I think the decision's been made. The province wants to see strong mayor powers delivered throughout most of Ontario. And if you look at it, I think the percentage of municipalities, if you add the 48 that were already granted powers, plus the 170, you're very close to 50%. I think it's 49.2 of all 444 municipalities in the province. So just think about it. Half of the municipalities in the province have now this authority, okay? So AMCTO strongly advocating against the strong mayor powers, as a number of other organizations have. I'll just leave that quote up, and there is a link in the under the Our Research words where you see the link to AMCTO's study. It's very simple. It's 2 pages. It basically says strong mayor powers have not led to a huge influx of new housing starts throughout all of Ontario. It really just hasn't. The ones that have come through, the ones that have gotten some money from the Building Faster Fund, the carrot that the province had dangled to some municipalities, already had many of these housing starts well underway at the time. Now, AMO, interestingly enough, has taken the most, lackadaisical, mansy-pansy kind of statement here, which I would say it's laughable, except that it isn't. And I've seen the president of AMO come out very strongly about how wonderful these powers will be, and I'm a little, I must say, I'm just a little aghast by how AMO has acted towards this. I'm wondering how some municipalities are feeling about AMO at this point. So, Madam Mayor, if I could, I'm just going to take a quick pause because now I'm actually going to get into the real meat. Are there any questions at this point?
Thank you. Thank you, John. I will turn to council, and I would be remiss. I apologize. In the invitation to staff, I didn't say that there would be opportunity for questions, but if you do have questions, we want to hear them. We are absolutely in this together. So if you're comfortable asking your questions today, that's great. If not, we can email them and have John address them at a later time. So if you do have questions, that's what he's here for. But I will turn to council if there's anything at this point. Councillor Moore.
Thank you, and thank you for your explanation. Wondering if any of these powers at this point are under any type of judiciary review, or if you've heard of any of that coming forward.
Yes, thank you, Councillor Moore. To you, Madam Mayor. Yes, I have heard of one. Only one at the moment. There was an application that was brought to the court in the city of Peterborough. This was the mayor exercising his power. I haven't gotten to it yet, but the mayor having exercised his power to advance a provincial priority. There has been an application brought to the court. The city of Peterborough was kind enough to send me a copy of the application just the other day, and I had a look at it, and I was really quite surprised. In my humble opinion, the application doesn't say very much at all. It basically says the mayor did this. Mayor shouldn't have done this, and therefore we're challenging it. I was quite surprised. It wasn't an application to quash, nor was it a judicial review application, which is what I thought would be. It's actually an application, and I don't want to get too technical with anyone here, but it's actually an application under the rules of civil procedure that, of course, lawyers know about, a Rule 1405 application, where someone can apply for a declaration that something isn't implementing something correctly. And that's how it was done. But I must say, the application itself is like 2.5 pages. It doesn't say anything. And the supporting affidavit that goes with it says almost even less, which is where you think you get some of the meat. So there has been one, Councillor Moore. I believe there's a court date of June the 10th, but I don't know if that's the date that it's going to be argued. Apparently, the solicitor who sent it to me was very kind. He said, John, I'm not really in a position to talk to you about it. We haven't even formalized our strategy and in how we're going to go forward. So I said, that's fine. I thank you very much for the application record. So there has been one. I foresee a number of other ones coming forward. The one that I thought we might have heard by now would have been the city of Orillia. You probably heard about that one. It's received a lot of notoriety across the province. This is interesting because I showed you 4 rollouts of the strong mayor powers. What I failed to mention was that the city of Orillia was on April the 3rd given temporary strong mayor powers, like other municipalities, for a temporary period, with the comment from the minister and the comment from Mayor McIsaac in Orillia that the powers were granted to deal with the state of emergency, which surprises me because I thought the strong mayor powers were supposed to be for building homes. So I'm just a little surprised. I would have thought that that one would have had some notice of application in, but I have not heard anything. And Councillor Moore, just to add a little bit more, this has been in place for 2 years, almost 2 years now. And apart from the Peterborough case, I have not heard of any other challenge coming forward, much less of one being decided. There is no jurisprudence that's been created. One of the questions that I keep being asked is, John, how are they going to interpret these? And I say, well, here's my best guess. But I said, we have no guidance from the courts. And there's been 2 years where 48 municipalities have been using these powers, and apparently there hasn't been challenges every day, and we have no judicial decisions. So that's what I can tell you up to this moment, unless someone's filed something yesterday and today, which I haven't been looking, Councillor Moore.
Thank you.
Thank you for that. And I think as we continue through this, I'm going to ask that our clerk keep a list of the questions and the avenue that you just produced or put forward as a potential for. I think council would appreciate more information on those steps. So Clerk Marshall, if you're able to kind of keep a list of the questions that are asked, and we can ask Ms. Mascarin to, in writing, provide again to us so that we can fully understand everything, as this is very new to all of us. So, Council, are there any further questions? Staff, do you have any questions at this point? And again, we will, any questions via email, we
Sure.
can do that as well. Please continue.
Thanks. Madam Mayor, what I'll do is, as you can see, there's 4 types of power. What I'll do is I'll pause after each one because there may be a whole bunch of things that you want to ask. This is the real meat of what I'm getting to. So I'll take a pause, and maybe that's a good opportunity then if people want to ask questions about that. So the first, I've categorized them in these classifications. I call the first ones administrative powers. The second ones I refer very specifically to provincial priority powers. I've seen a number of municipalities refer to these ones as legislative powers. Okay, they're legislative powers, but they can only be exercised for provincial priorities. So I think the better moniker for them is called provincial priority powers. So that's just my liking. Then there is the budget power, or Madam Mayor, as you may correct me when I get to that point, you might call it the budget responsibility, and I'll speak that. And then I've categorized a bunch of things that aren't necessarily powers, but I put them all under, this is a variety of things, or this is the miscellaneous basket clause at the end. And I'll try to maybe reference some back and forth so it might make some sense, so you're not waiting for the miscellaneous things to come into play. So you'll understand as I go through. So the first one's administrative powers. If you read the Collingwood Judicial Inquiry from Justice Morocco from a few years ago, which really dealt with what is the authority of the mayor, what's the authority of council, what do individual members do, what does staff do? It was very, very clear, and Justice Morocco wrote, no member of council, comma, including the head of council, comma, has any unilateral authority to give directions to staff to do anything in particular. And that's true. That was the law. This has now changed. The mayor, Mayor Coughlin, now have the authority to direct employees, municipal employees, that's the word in the term in section 284.3, to undertake research and implement your decisions and provide advice to you and the municipality. So this is really interesting. This, if you're wondering, this sounds kind of familiar. You would have seen this in section 228 of the Municipal Act. You'll still see it there. And it says council can direct staff to undertake research and to report back to council. Well, this has now changed the rules a little bit, right? It's now allows you, Madam Mayor, unilateral authority to give directions to staff to do certain things, to give advice, research, do certain things to you, but also to the municipality. And people ask me, what does the municipality mean? Well, my view is it doesn't say to council and it doesn't say to staff. So my view is I think municipality is being used in a general sense to include, well, to give advice to council and to the municipality in general, to staff. However, now that I've said that you can direct staff, you are only allowed to exercise the direction to staff for the purposes of Part 6.1. Only for the purposes of exercising the strong mayor powers. So, Justice Morocco's words from the Collingwood Judicial Inquiry report still ring true that no member of council can direct staff unilaterally for everything except for, Madam Mayor, you are allowed to direct staff now with respect to your powers under Part 6.1. What are those? Well, it extends to the general control and exercise of the management and affairs of the municipality, and for the purposes of advancing provincial priorities, or for the purpose of trying to preclude any potential interference with provincial priorities. That's in encapsulation of what Part 6.1 says. Now, the question I've been asked is, can the mayor just give verbal advice, verbal direction, oral advice. No, it all has to be put in writing. And you'll see that there are requirements for when the mayor does this, that the clerk has to receive it and has to make it available to other persons. So there is some transparency and public accountability to this. So it's not simply come to my office and do this. It's writing a formal direction that must be somehow registered, logged, captured, however you want to call it. And your clerks will be well aware of some of those requirements. And I'll speak a little bit more about those. So you can give directions to staff. The second power, this is the one that has received quite a bit of media attention, is the authority of the mayor to hire and terminate, or to appoint and or to revoke the appointment of the chief administrative officer of the municipality. So many people have misread what section 284.5 says, and I'm just going to read it to you. I have it on my other screen. The powers of a municipality under section 229 with respect to the chief administrative officer are assigned to the head of council. A number of persons have misread that. They believe that what it says is the powers of the chief administrative officer to run the municipality have now been transferred to the mayor. That's not what it does. Section 229 says the powers of a municipality are to appoint a chief administrative officer. So that's the power that's been conveyed to the mayor. It's not the actual power of the chief administrative officer. However, if you think about it, the mayor, who now is in charge of hiring, firing, appointing, or revoking the appointment of a chief administrative officer, essentially now there's a blurring of the governance arm, the executive governance arm, with the administrative operational management arm of the municipality. This is really interesting. I've often said, and I don't mean to be disrespectful to anyone, neither heads of council nor chief administrative officers, but I've said when a chief administrative officer first was primarily the one employee that council had, and that he or she had to provide neutral, impartial, politically objective advice. Now, because they can be hired and terminated by the chief executive officer of the municipality, in many ways, the chief administrative officer has become the chief of staff of the mayor. Okay? Now, there are also powers with respect to local boards and committees, but I want to be really clear about that. The wording is prescribed local boards and prescribed committees. So let me take the suspense out of it. There are no prescribed local boards. Okay, so if you're going to ask me, oh, does the mayor have authority to appoint the chairs and vice chairs of the library board, the police service board? No, those are not prescribed local boards. There are none. And when the words prescribed are used in a statute, what the word means, it's not its ordinary dictionary definition. It means it's set out in a regulation. Okay, and there is nothing in Regulation 530.22 which gives a meaning to what a prescribed local board is. So at the moment, it is an empty shell. If there are any prescribed local boards, then the mayor will have the authority to appoint the chairs and vice chairs, and consequently to remove any chairs or vice chairs that may be there. But at the moment, it's an empty shell. There's no power. With respect to prescribed committees, there is a definition. In the regulation, in the Section 4, the term committee is defined as being a committee comprised of all members of council. Typically what you would think of as a committee of council. Okay, so with respect to committees of council, where the committee is comprised of all members of council, the mayor has the authority to dissolve those committees, to create committees, to assign their terms of reference, their functions, and to appoint chairs and vice chairs. So for prescribed committees, if your municipality has any, the mayor can, for instance, dissolve a committee of the whole and say, okay, I'm dissolving the committee of the whole because it's comprised of all members of council. And I'm reconstituting the committee of the whole, but only with these functions or with other functions. The mayor is entitled to do that. Okay. The mayor is also entitled to then handpick the chair and vice chair. Those are powers that are now available to the mayor. Now, with respect to both of these powers, and I will get to this, they can be delegated by the mayor back to council. Both of these powers, the CAO hiring and firing power and the powers dealing with prescribed committees, the mayor can delegate those powers back to council. Okay, I'll show you the authority a little bit later. The fourth administrative power, and it's a big one, is the mayor has the power to determine the organizational structure of the municipality. You may be saying, what is the organizational structure? I'll tell you, I don't know exactly what it is. I looked up a dictionary definition of what it is. I asked two of my employment lawyers that often help me with municipalities, and they said to me, John, the term organizational structure is not a term of art in employment or labor law. It is not used in the Employment Standards Act, in the Occupational Health and Safety Act, or in the Labor Relations Act. Now, let me tell you, I was a little surprised. I went and looked myself. I thought it would be in one of those. It's not. So my employment lawyer said to me, and I had come to the same conclusion, the province chose these words to give it some open, flexible type of interpretation. Organizational structure basically is the organizational chart of the municipality. Who reports to whom? What are their silos of responsibility, essentially? That is what it is. The mayor now can set the organizational structure. So, Madam Mayor, if you don't like the way the organization of your municipality is set out, you don't like that there are, 4 department heads or 4 commissioners or 4 directors, and you'd like to see 7, you're entitled to do that. You're entitled to do it the other way around and reverse what I've just said. Create 4 out of 7 or whatever. You're entitled to do this. You don't have to have any HR, management, industrial relations, which was the term when I went to school, experience or knowledge or expertise but you're entitled to do this. And some mayors have certainly exercised those powers in the second and third groups of municipalities that came forward. Now, the organizational structure, that power, includes the power to hire and terminate the employment of any division heads or persons who had divisions. That is the actual language of the statute. And I've put there department/division heads because I think the word department, I think, resonates more, at least it does to me in dealing with municipalities. Again, what is a division head? I've said to many municipalities, I don't know. But if you show me an organization chart for your municipality and I get to speak to the HR director, I might be able to figure out who a department or division head is. Now, you understand that if the mayor is able to set the organizational structure, the mayor must be able to have this power as well. Otherwise, how could they possibly determine what the structure is and how the divisions will work? Now, there is a carve-out, and it says the power to hire and terminate division heads does not extend to an officer or a person who is a division head, but who is a statutory officer, or is another officer that is required to be appointed under any other act. Okay, so you've got your statutory officers, and I've got a few of them on the screen: the clerk, the deputy clerk, treasurer, deputy treasurer, fire chief, auditor, CBO, and so on. Those are what you think of as statutory officers. Okay, now there are other persons, for instance, building inspectors that need to be appointed by statute. Weed control officers. I didn't know this the other day until I was asked the question. They must be appointed by statute, by council under statute, under the Weeds Control Act. I did not know that. Those people can't be removed by the mayor if they were a division head. One of the questions that I've been asked is, what happens if someone is jointly appointed, or not really jointly appointed, but appointed as a hybrid? So for instance, CAO slash treasurer or CAO slash clerk. My view is, even though the CAO is not on the list here, the CAO likely, if it has, he or she has that dual function or even multiple function, and it was appointed in that way, I think that person is ousted from the mayor being able to hire and fire the CAO. Now, what happens if the CAO slash clerk was first appointed as the clerk and kept that title, but then was also appointed, cross-appointed as the CAO? That's a really interesting question. I'm not sure that they would be saved because it's not a hybrid appointment. Did the province think of this? Hell no. The province didn't think of any of this, probably didn't think of, when it first put this in place, that it would be extended to like half the municipalities in the province, many of whom have these hybrid functions or hybrid appointments to office. Now, there are several transitional provisions in this particular section. First, I want to highlight just two of them. The first one is any existing organizational structure remains in place unless it's changed by the head of council. Okay, and any person who was employed on May the 1st remains in that position unless the mayor is removing them from their office. Now, can the mayor, the head of council, remove someone without cause? The answer is absolutely yes, they can. But it isn't completely with impunity, because someone who has been working at the municipality for a number of years, let's just say you have, and I'm not picking on anybody here, but let's say you have a senior statutory officer, whether that's the chief building official, the treasurer, whoever, okay? Well, I picked two that are statutory officers. Sorry, let me pick two that aren't statutory officers. Let's say there's a chief planner and a director of bylaw enforcement. I don't know if that's in your municipality. Let's just say those are not statutory officers. The mayor can dismiss those persons, can dismiss them without cause. But if those persons had worked for the municipality for 15 years, 20 years, 10 years, they are entitled to their vested employment law rights. So notice, severance, and in certain instances, perhaps also other damages. And I say that because my employment law lawyers have said, don't just say notice and severance. There may be some instances where there may be damages. So that is the organizational structure. You can see that these powers are quite extensive. Directions to employees, municipal employees. Doesn't say just upper echelon. I doubt the mayor would want to give instructions to the seasonal summer grass cutter, but you may be able to interpret municipal employee as going down to that level. I don't see why there would be a restriction otherwise, because the term was municipal employees. The chief administrative officer now is the employee of the mayor. Mayor has powers with prescribed committees, and the municipal organizational structure is now under the mayor's purview and jurisdiction. So, Madam Mayor, I've come to the end of administrative powers. I'm wondering if anyone has any questions about any of these.
Cabral.
Thank you, Mayor Coughlin, and through you to Mr. Miskaren. Mr. Miskaren, this brings up kind of a unique situation when you have a CAO who has an exit clause. How does that work with the contract? If someone has an exit clause where if they are terminated, they get a year's salary, is that still going to be, would you still have to pay that, or does this legislation prevent that from moving forward? Nullify that particular contract. I'm just wondering about that one. Because it is
thank you.
something that seems to be coming up now.
Yeah, thank you for the question through you, Madam Mayor. I was getting to this in my last comment when I said an employee's vested employment law rights. And I was thinking of, the common law, which, if you've worked somewhere for a number of years, you're certainly entitled to certain things. If you have an employment contract that has a certain clause in it, like you said, a CAO dismissed automatically gets 12 months, 18 months, 24 months, whatever. That still remains in place, and that would have to be honored. The only way it wouldn't be honored is if the person was dismissed with cause, and then you'd have that. But those have been put in place. I can let you know, we were retained by the Ontario Municipal Administrators Association to create a CAO contract, and one of the things that was asked of us was to protect chief administrative officers. And we said, well, what are you thinking of? And we said something that says if a strong mayor comes in, they can't remove them. And we said, we can't do that. You can't contract out of a statute. So it would be against public policy. So you couldn't have that. However, a strong mayor CAO who's negotiating a contract could say, you know what? I really like you, Mayor Coughlin, and I think I can work really well with you, but I don't know what may happen in a year and a half from now, and I need to protect myself. So I'd like an exit clause that will pay me 3 years' salary if I get removed from office without cause. I mean, you could see some of these things. We certainly were asked those sorts of questions, Councillor, when we were giving advice to OMA on what types of clauses would be feasible, palatable, and legal to put in CAO and other senior administrator contracts.
Thank you for that. Anything further from council? Anything further from staff? We can carry on.
Thank you, Madam Mayor. The next group of powers are the provincial priority powers. So here's the regulation. I don't think I've cut it down. This is exactly what it says. The following are provincial priorities for the purposes of 3 sections of the Municipal Act, the 3 sections that I'll be talking about. So what are the provincial priorities? As I said, building 1.5 million new homes and constructing and maintaining infrastructure to support housing, which includes transit, roads, utilities, and servicing. So those are this government's provincial priorities. I was asked an interesting question the other day. I was asked, well, what if the provincial Conservatives had not won the last election? Let's just say the NDP had won it and Merritt Stiles was our premier. Could provincial priorities change? And my answer was absolutely yes. The NDP, the Liberals, or any other government, the Green Party, might have a whole different worldview on provincial priorities. You could see provincial priorities being potentially climate change or diversity, equality, and inclusivity, right? It depends on the provincial government of the day. Our provincial government has been very clear. Building homes, that's what these powers are supposed to be used for. So here are provincial priority powers. As you know, every municipality must have a procedure bylaw. In fact, this might be an exam question. Name me another mandatory bylaw that a municipality must have. I'm always hard pressed to name another one, but a procedure bylaw is one. Municipality must have a procedure bylaw. That's typically sets out things like the calling, place, public notice, and what are the rules when you're at a meeting. Well, for the exercise of provincial priority powers, the head of council can override what the municipality's procedure bylaw actually says in order to do certain things to advance provincial priorities. So, sections 284.10 and 284.11.1, and I'll speak to the second one in just a moment. So, the mayor now has some super powers when it comes to meetings. She can override your procedure bylaw in certain instances. Now, the mayor also has a veto power. This is under section 284.11. So, the mayor is given the authority to veto any bylaw that's enacted under the Municipal Act, under the Planning Act, or any prescribed statute. And there has been one prescribed statute under the regulation, and it's Section 2 of the Development Charges Act, in effect, a development charge bylaw. If the mayor is of her opinion, not anyone else's, if she is of the opinion that any bylaw passed under those three statutes potentially interferes with a provincial priority, she has the ability to attempt to veto that power. So just let me bring it back. There is veto power given to the head of council for any bylaw under the Municipal Act, any bylaw under the Planning Act, and any development charge bylaw, if the mayor has the opinion that that bylaw or parts of that bylaw, it doesn't have to be the entire bylaw, could be parts of that bylaw, potentially would interfere with a provincial priority. Now, let me give you a couple of examples, and this might help. Development charges, what do? Development charges impose a tax on land to pay for the capital cost of building infrastructure that is needed for new development. I've just distilled Section 2 of the Development Charges Act down for you, okay? Development charge bylaw then will set certain rates, development charges, for certain categories of development. Institutional, commercial, and residential. So, could a mayor potentially say, I would like to veto the development charge bylaw, but only with respect to the residential development charges? I'd like to veto that portion of it. The mayor is entitled to attempt to move that forward. Now, that's a simple one. Now, under the Planning Act, what does the Planning Act do? It typically allows for subdivision approvals, consent approvals, rezonings, official plan designations. You can see how all of those might relate to the construction of housing. Okay, so I won't spend too much time. But you might be asking, what about the Municipal Act? The Municipal Act doesn't typically talk about housing in any way. Well, just think about this. You have a dire need to have residential development in your municipality. Let's just take that as a given. You do. Your noise bylaw that's passed under, I think, Section 129 of the Municipal Act, it has certain periods of time where things are supposed to be quiet. You're not supposed to have noise or vibration, right? Typically, I don't know, what is it, 7 p.m. to 7 a.m., not on holidays, maybe not on weekends, or maybe not just on Sundays, things like that. What if the mayor says, you know what? I don't think that's appropriate. I think I'd like to veto certain things in the bylaw, including the section that has quiet periods. I would like to have 24/7 construction activity. Possibility, right? It's a possibility. So that's just an example of where it may fall potentially under something that you might not have thought about, the Municipal Act. I think that's why they put in there. Now, if the mayor would like to veto a bylaw, the first thing that I want to say to you, it has to be a recently enacted bylaw. It can't be an historic bylaw that's in place. It has to be something that council is now enacting. So, for instance, if you pass your development charge bylaw or your noise bylaw some time ago, the mayor can't go back and veto those bylaws, okay? The mayor can only veto a new bylaw. And why do I say that? It's because the veto power can only be exercised if the mayor gives notice to council within 2 days of the vote of council to pass the bylaw, and then exercises her right to actually veto the bylaw, which she must do by providing notice, written notice, and reasons in support of why she's vetoing the bylaw. And she must do that within 14 days of the original meeting of council that passed the bylaw. Okay, so there are limits on which the mayor can do this, right? Now, here's where it gets interesting. Council can override the mayor's veto, but only by a supermajority vote of 2/3 of council, and can only do so within 21 days of the date that the clerk has provided the notice that the mayor was going to veto the bylaw. So the mayor has to do that within 2 days, provide notice within 2 days of the bylaw being enacted. That means within 21 days of that date, the mayor, the council can seek to veto the, override the mayor's veto. Now, there is some wording there that says 21 days or any prescribed date. There is no prescribed date, so I just want to let you know. The mayor is entitled to vote on the veto, on the override, potential override. So it makes it a little more difficult to override. And the veto power does not apply to certain bylaws. Sections 289 and 290 are the budget bylaws. Okay? So very interesting provisions, things that your clerk will really need to pay attention to and how this works. The other question I was asked is, when we're talking about a 2/3 vote of council, or you'll see in just a moment, more than 1/3 vote of council, does that mean members of council who are present at the meeting, or the entire numbers of members of council? My interpretation, and this has not been set out in any judicial decision, nor anything in the statute, my view is, if the legislative drafters wanted to say it is a 2/3 vote of the members who are present, then it could easily have said that. And there are instances in certain statutes and in regulations where those words are specifically used. The fact that it just says a 2/3 vote of council, to me, means a 2/3 vote of your entire council as it's constituted. So it's not just the people who are present. So some of you may be saying, but we could possibly have a meeting that meets quorum, which is, just a majority of the members of council. But then how could we ever possibly achieve a 2/3 vote if we're having it during that meeting? And the answer is, you may not be able to. I think this was intended. The other question I was asked is, 21 days, what if there's no council meeting within those 21 days? I don't know how they picked that 21 days. I think the province probably thought 21 days plus potentially the 2 days notice is 23 days. That's a lot of time. It may not be. What happens if something is done over a holiday period, for instance? So it could be really interesting. Some municipal councils do not have the ability to call special meetings unless the mayor agrees. Now, I haven't seen too many of those, but I have seen a few, and that's going to be interesting if the mayor exercises his or her strong mayor powers, and then there is no meeting for which council can vote to veto. Anyway, interesting points. Finally, this was added by the Better Municipal Government Act, by Bill 39. This is the corollary to the power that I just showed you, where a mayor may be able to veto a bylaw that that interferes with the provincial priority. In this case, despite any procedure bylaw, if the mayor is of the opinion that a bylaw under the same statutes that I talked about before, the Municipal Act, the Planning Act, or Development Charge bylaw, potentially could potentially advance a provincial priority, the building of housing, then the mayor may propose the bylaw with supporting reasons, has to provide supporting reasons, and require council to vote. And the vote is not a majority vote. This is the one section, I think a lot of people are arguing about the whole act, but this is the one section where people say, this is undemocratic because you can, with more than just 1/3 of a vote, have a bylaw enacted. You don't need a majority any longer, which goes against our system of local governance, as I've said, here in Ontario. So again, the mayor can form an opinion that a bylaw may potentially advance a provincial priority, and she can bring it forward, propose it with supporting reasons, and require council to vote. That is really interesting language. I've had a few councils say to me, what if we all get up and leave and quorum is lost? Well, it says the mayor can require you to vote. That is really interesting language. I don't know how this might play out, but it'll be interesting if a council or some members of council decide, I'm going to let quorum get lost by exiting the meeting. And that means the matter can't go ahead. I think that would be an illegal act, quite honestly, because the mayor can require you to vote. So that means you'd have to stay at the meeting. And the words here are more than 1/3 of council. It doesn't say 1/3, it says more than 1/3. So my view is you get the number of members of council. If it's 7, you go, what's 1/3 of 7? Well, it's 2.3. Okay. You can't have 2.3, but for these purposes, that's important. So you get 1/3 of council, you have the mayor who votes, she will vote. It'll be 3.3, that's more than 1/3 of council for councils that are 7 or 8 members, okay? If you have 9 members on a council, then more than 1/3 is 3 + 1, so you'd always need 4 in that case. And as I indicated before, the head of council is entitled to vote on a bylaw to pass on the bylaw to advance the provincial priority. So 1/3 of council plus the mayor equals more than 1/3 vote. These powers can only be used for the prescribed provincial priorities. So there's 3 aspects of that: the meeting override, the veto power to veto any bylaws that potentially interfere, and the bylaw enactment power for bylaws that potentially advance a provincial priority. So, Madam Mayor, that's the end of provincial priority powers. Does anyone have any questions about these things?
Thank you, Mr. Muscarin. Before I turn to council, we have 15 minutes before our next meeting does start. We can push the next meeting a little bit, but I just wanted to be mindful of the time. I don't expect this question to be answered at this time, but I have been curious. When we speak to a quorum of council, currently under the Municipal Act, that in our state in Springwater would be 4 members of council. When members of council are speaking about a directive, motion, or veto under strong mayor's powers, what is quorum? And I'm saying that because I want to be ensuring that I am executing these powers rightfully. Am I able to still speak to 2 other members, or does that become quorum? Because that would be that's how the vote is taken. So I don't expect an answer today, but I would just appreciate if you could follow up with that so that we continue to conduct ourselves properly in Springwater.
Yeah. One interesting power, and Madam Mayor, I'm sorry, I thought we were on till 7. I will speed it up and get through through this, so I apologize for that. It was my error. I can't answer. One of the interesting questions that someone has brought up is, you can recalculate quorum under under the Municipal Conflict of Interest Act if people declare pecuniary interest. I'm not sure how that factors in, and I haven't thought that through. And I think I thought about it a little bit, but I tried to bounce it off someone who had a very different view than I did. So I'll take your question when it comes and be pleased to try to answer it for you. It's an interesting one. Were there any other questions?
We do have one from staff. We have.
That those bylaws be amended, and then when they come forward, they're going to veto them.
Thank you. And the question, we would add that to the list because I'm sure that's something that's just come up. So the question is, the direction from the mayor to staff, understanding that we cannot veto existing bylaws. Can direction be to amend, or understanding right now it's simply research and work to be reported back? But if we could better qualify, whether it's DC bylaw or procurement bylaw or whichever the bylaw it is, can the mayor direct staff to amend bylaws, like pre-existing bylaws? And we'll leave that for.
Yeah. I can answer. I can try to answer that now. I think the answer is yes, Madam Mayor. If you feel that those bylaws can advance provincial priorities, you can give direction to staff to come back, review whatever bylaw it is, and come back with a proposal that then you can bring in front of council to seek to advance it. So an existing bylaw, the noise bylaw, for instance, you can't veto what's in there, but you can come back, say to staff, look, I'd like to extend the building times for people from whatever times it is, make the changes, and you could bring that forward as a bylaw under the authority that's on the screen right now.
Thank you. So that would not be done through an order. That would be done through a bylaw.
Yeah.
Perfect. Thank you.
Yeah.
We'll get. I'm not seeing anything further. If we could.
Okay.
Briefly go through the and we can reschedule this again if more questions come up and we can have more time. Like, we don't have to get everything in here. We can have questions come through our clerk. And if we feel that we need to have another session with Mr. Mascarin, I'm sure he would be available.
I'd be happy to make myself available, Madam Mayor. So I'll get through this so we can at least get the presentation done. So now the budget power is the mayor's power or responsibility. It is no longer council's budget. It is the mayor's budget, and the words are, mayor, the head of council shall prepare the budget on or before February 1st. The head of council does not have to wait till February 1st. That's just the end date. Many misunderstand what that says. If you don't propose the budget by that date, so next year's budget by February 1st of next year, Madam Mayor, then the council has the power to do this. You do not have the authority to delegate this power, okay? You can't assign the power, you can't delegate it. However, you can instruct staff, for instance, to bring forward a process for considering the budget as we have done in the past. So if there's a budget committee, there's public meetings, there's, I don't know, whatever else may be involved in the budget process, you could instruct staff to do just that and to move it forward. The one difference is, Madam Mayor, at the end, instead of the budget coming to council at the very end, the budget comes to you, you bring it to council, and if council doesn't approve the budget, council can propose amendments. But you can then decide to veto any of council's amendments. Council then has the authority to veto or override your veto by a 2/3 vote. So almost the same rules apply. That's the budget power. I won't go into it any deeper, but it could be as simple as I've just indicated. It could be much more complex. And again, the mayor does not have to be a chartered accountant to be able to do this. The mayor could, for instance, give direction to the treasurer or the finance department, come back, process a budget, but I'd like to see a 0% tax increase or a whatever. You could do that. That's the direction that you could give. It's in your authority. Finally, I'm just going to quickly go through the miscellaneous powers. I've talked a little bit about this delegation. So, Madam Mayor, and members of council, when I just said the mayor cannot assign or delegate the budget responsibility, that's because the statute has a delegation power and it only applies to these 4 things. So that must mean the provincial drafters thought about it, turned their mind and said, this is what we're going to allow to delegate. And if it's not named, then you can't do it. You are entitled to delegate powers respecting the chief administrative officer back to council. The organizational structure, you can delegate that back to council or to the CAO. You can't delegate to anyone else, like a committee or anything. Local boards, they're not there now. And committees, prescribed committees, you can delegate your powers to create committees, dissolve them, give them the terms of authority, and to appoint the chairs and vice chairs. You can delegate that back to council. All of these delegations are done in accordance with my first bullet under section 23.1 sub 2. Those are the ones that say when someone delegates the power, they retain the power to revoke the delegation. So if you were to delegate this power today, Madam Mayor, and you're very comfortable with your council today, and you say, okay, I'm going to delegate these powers back to council. Let's say you're reelected, but the same council isn't, and you're not so sure about that council. You might want to take back the delegation power, revoke it. You're entitled to do that. Madam Mayor, you're not reelected or you don't run for office again next term. There's a new person there. That person can revoke the powers. The decisions that you make as a strong mayor remain in place until they could possibly be revoked or repealed. Okay? There's an immunity power. It basically says that no decision or veto power or any other power that you exercise can be open to be quashed or reviewed by a court, so judicial review or an application to quash, if you act legally and in good faith. And that makes sense because sections 272, 273 of the Municipal Act say if you act illegally or in bad faith, that's grounds for quashing. And 273 talks about you cannot challenge a bylaw for being unreasonable, unless, of course, it is so unreasonable as to go to the very vires of the authority to do so. So someone asked me today, so what happens? Does this get rid of OLT appeals? Like, if the mayor gets a bylaw passed, a zoning bylaw passed, does that do away with an OLT appeal? The answer, in my view, is no. It says shall not be any of those things shall not be quashed or open to review. My view, the wording is chosen specifically. A quashing is an application under section 273 of the Act, and review is a judicial review, not a review by way of an appeal under the OLT. So I don't think it gets rid of that, okay? The head of council of a strong mayor municipality can only be elected. So, Madam Mayor, if you were to step down and resign your seat right now, council typically can appoint someone under section 273 or can run a by-election. In the case of a strong mayor, the mayor can only be elected, okay? And I've extrapolated a deputy mayor or an acting mayor or an interim mayor, however you want to call it, does not carry with him or her the strong mayor powers, even though they may be acting as the mayor. So your procedure bylaw may say something about delegating authority for when you're not at a meeting to the deputy mayor. That's fine, but that's only for running the meeting. It is not to undertake and have any of the strong mayor powers to veto, move forward a bylaw, and to override the procedure bylaw. All of the requirements for directions, decisions, and vetoes must be in writing and has to be produced by the next business day and given to each member of council and to the clerk, and be publicly accessible subject to any restrictions of NFIPA. I've been asked, what if the direction was something that would normally be done at an in-camera meeting? Then the direction would have to be very, very carefully written so you don't actually give away. But it may be directions were given to staff to undertake certain matters that are subject to the closed meeting exceptions or something like that. I know municipalities have worked this out. This is something, again, I'll probably saddle your clerks with because I haven't had the experience, but I have been asked the question. Now, for public transparency and accountability, everything has to be in a written format. Many municipalities, I think all of them, have set up separate web pages on their municipal website where mayoral decisions or mayoral directions are all listed, and vetoes. So they're all listed often in 3 categories. Or you can have 3 separate web pages. That's up to the particular municipality. So that's how people would actually look these things up to find out, does anything override a bylaw? And of course, if you vetoed a bylaw, you need to be able to see that. So that's how due diligence is undertaken by the public. And finally, there are provisions dealing with the head of council when the head of council has a pecuniary interest, direct, indirect, or deemed, under the Municipal Conflict of Interest Act. The member, the head of council, is not able to exercise the strong mayor powers if they have a pecuniary interest, and they have to file a written disclosure with the clerk. Typically, you would have to do that if you're at the meeting, right? Well, section 6.1 says, 5.1 says that you have to file it if you're at a meeting. Well, now you may be exercising some of these things outside of a meeting, so you'd have to do that. So you can't use your strong mayor powers if you have a pecuniary interest. So, Madam Mayor, I've come to the end here. Strong mayor powers are limited executive powers and authorities, but my oh my, they're very significant. They are administrative powers, powers related to provincial priorities. There is the budget power, responsibility, and there are some other things there. One final comment is these are in place now. A municipality can't go and disclaim them now. And I say to councils, and I wasn't a big fan of this legislation, you got to live with them. That's the law now. It's the law. The mayor has these authorities. Try to work with the mayor on these matters, right? Maybe the mayor will be listening to you, right? It's in place. There's no rolling back of time now. So, Madam Mayor, I've come to the end. I'll stop sharing my screen, and I know I haven't left too much time, but I'm happy to answer any questions that may be still existing, and but I know you have another meeting to go to.
Thank you for that. Counselor, are there any questions of Mr. Mascarin at this time, understanding that we do have access by email, and if we choose to have a secondary meeting to follow up with those questions, we can do that as well. I'm not seeing anything at this time, so I will again put it out to staff and to council that should there be any follow-up questions, to please submit them to the clerk, and the clerk will get those to Mr. Mascarin, and he will respond to all of us. And then if we do see a need at another date to have a follow-up meeting as things roll out and we all learn together, Mr. Mascarin, I would like to thank you for working with our clerk. Our clerk has done a phenomenal job of diving into this. I think that the transparency that she's provided, we actually have a separate section on our agendas that we're going to move forward with any of these moving forward. This is a learning curve for everyone across the province, and we want to make sure that we do it right. So as we continue to proceed, I'm sure we'll have many questions as we go along.
Madam Mayor, I wanted to say thank you very much. I'm very privileged to be here. I remain available, and I must echo your words. Jennifer has been asking me some really great questions. She's really thinking about this, and I thank you again. And I will remain available should you need anything going forward. So thank you for the opportunity to present tonight.
Thank you. Council, may I have the mover and seconder to receive the delegation, please? I have Councillor Thompson and Councillor Fisher that the presentation from John Mascarin regarding the overview of strong mayor powers be received. All those in favor? And that has carried. And mover and seconder for the confirmation bylaw, please. Deputy Cabral and Councillor Garwood, that bylaw 2025-038 to confirm and adopt the proceedings of council at the special meeting held on May 7th, 2025, listed here and be signed and sealed by the mayor and clerk. All those in favor? That has carried. And our adjournment, please. I have Councillors Moore and Thompson that the special meeting of the Township of Springwater does now adjourn at 6:29 p.m. to meet again in a regular meeting at 6:30 p.m. All those in favor? And that has carried. And that meeting is adjourned. Thank you. I am going to ask the indulgence of the public and staff that we can have a quick 10 minutes here before we begin again, and we'll be back as 10 minutes. Okay, council? Great.